My name is Troy Cates, and having already made a knowing and intentional decision to allow one judicial officer, within Alabama's 14th Judicial Circuit, Walker County, to continue to live, I am writing today to warn the general public of the deceitful nature of the current presiding Walker County Circuit Court Judge, Jerry K. Selman, and the current Walker County Circuit Clerk, Susan Odom, who just won an unopposed third term in office. I first started following House Bill 688 before it was passed into law. Media reports on the bill mentioned a bond fee being added to all bonds executed. And because issues of bail and the willful abuses thereof are among my biggest pet peeves, I looked into the bill. Once passed, the bill created two bond fees. Only the pre-conviction $35 fee is relevant to the practice that I call the practice of imprisoning my brother until I pay my debts. Though, the post-conviction bond fee is unconstitutional on its face, in that it only applies if convicted and it uses bail bond as punishment for a crime. This bond fee is levied against the person executing the bond and not on the person being accused of a crime, except when the accused is the person executing the bond. It appears to me that the legislature went to great lengths to create a bill that fully respects Article 1, Declaration of Rights, Section 20. Imprisonment for debts of the Constitution of Alabama, which has been interpreted to prohibit both the imprisonment for debt and the threat of imprisonment to coerce payment of debt. The bill gives the person 2 days after executing the bond to pay the $35 fee. It also created a statutory specific contempt offense to punish those who do not pay the fee within the required 2 days. It also allows for the payment of the fee at the time of execution. But at all other times it required the fee to be paid at the clerk's office. This statutory specific contempt charge is wholly different from the court's normal contempt powers, in that it does not authorize imprisonment for non-payment of the fee. But it does create a civil fine of $500 for such non-payment of the $35 bond fee. On July 6, 2012, a local publication of daily circulation published an article about the newly passed bill, in which the cut-and-paste rag quoted Walker County Circuit Clerk Susan Odom as saying that addition to raising costs, the bill also added a $35 filing fee on bonds executed in a criminal case that must be paid in advance. She was the first government official that I am aware of to make the claim that the bond fee must be paid in advance, and she was the first government official who suggested that they will not release a person from jail until the bond fee is paid in full. On July 12, 2012, I sent an email to the 3 Walker County Circuit Court judges, warning them that implementing the procedure as Mrs. Odom stated would violate Section 20 of Alabama's Constitution and would constitute a color of law crime. I also sent Mrs. Odom a carbon copy of the email. I made several attempts to get other people involved in stopping the practice, but failed to get anyone involved. On March 2, 2015, a close friend of mine was arrested on a DUI charge. He was placed on a 24-hour hold and denied a phone call until March 3. I missed the call from the bondsman. But after I checked my voice messages, I called the bondsman. She claimed my friend needed 1. Someone to sign bond, 2. $150 for her fee, and 3. A $35 money order made out to the circuit clerk to but given to the jail, or they will not release him. I then called the jail and was told his bail was set at $1,500, and to make bail all that was needed was 2 people with Alabama identification, who have not been convicted of a felony, and that a $35 bond fee must be paid in advance or my friend would not be released. I was also told that there would not be a person available to approve the bond until 8 a.m. the following morning. On March 4, my mother and I went to the jail to make bail. I was again told that my friend would not be released without the bond fee being paid in advance. I then walked across the street to the post office and purchased a money order. After signing the bond and paying the bond fee, I was not given 1. A receipt for the bond fee, 2. A copy of the bond, 3. Or a copy of the bail transmittal form. However, my friend was given a copy of the actual bond and a copy of the bail transmittal form. Additionally, I was told that there was no one available to approve the bond and that it might be a few hours and that it might be best to go home and wait for my friend to call. We went home and I then posted a Facebook comment belittling the procedure and tagged Mrs. Odom and Sheriff Underwood, which reads in relevant part as follows: and yet I'm waiting on Sheriff's office to do Susan Odom's job. Because Sheriff Jim Underwood does not allow people to bail out of his jail at night, but will provide an employee to approve bail during regular business hours except when everyone has court. My friend was released around 11 a.m. that morning. On March 5, I went to the circuit clerk's office primarily to look up a list of names that I believed to be a lost list containing names of possible victims of the local judicial roguery. Unfortunately, I had forgotten the list at home and I only looked up 2 cases, my friend's and Robert Hart's cases. While sitting at the public access computer, Mrs. Odom walked past me and said, "Hey there, Mr. Troy Cates." I replied, "Hello, how are you?" She then said, "Oh, I'm doing just fine," and turned toward me and bowed while saying, "Just doing my job." I was amused by the theatrics in making her statement, but it was obvious that her intent was to express animosity for my Facebook post. I have since edited the post, untagged her and removing her name entirely. I have also blocked her on Facebook. On March 8, my friend was charged with public intoxication. I received his call for help at 7:25 p.m. A jail employee was kind enough to allow my friend the use of the regular landline on the booking desk, so I had no trouble understanding the actual words used and had enough time to question and clarify the substance of what he was saying. My friend told me that we needed to be at the jail by 8 p.m. and that they will release him at midnight. He said something about a 4-hour hold. I took that to mean a civil commitment that happened by operation of law and without any judicial involvement or oversight or intent to reflect its adjudication within the official court records, in any way. We arrived at the jail just before 8 p.m. And because neither of the 2 places that we stopped at, while en route to the jail, sold money orders, I walked my mother into the sheriff's office. I then went directly to the Kangaroo on the corner of Airport Road and Highway 118 and purchased a $35 money order. Upon my return to the jail, I gave the employee the blank money order. Oops, she appeared to have wrote on it and then detached the receipt from the money order and advised me to save the receipt of the money order and that I will need it to prove I paid the bond fee, because they can and do get lost. I am of the strong opinion that the possession of the receipt which was attached to the money order only proves the purchase of the money order from the Kangaroo and not the actual payment of the bond fee. We were told that my friend would be released sometime after 8 a.m. the following morning. I assumed this was because of local procedure forbids the approval of bonds at night. But it could have been because someone chose to extend the hold until the morning. On March 9 in the earlier morning hours, I took my sister to work with the intent to use the car to pick up my friend from the jail, help him find his truck, and then pick up my sister from work. My friend was released around 8:30 a.m. and we had no troubles finding his truck, so I was home by 10:30 a.m. Later that afternoon, my sister called and asked me to bring her a lunch and to run an errand. When I completed my tasks, I decided to go to the courthouse with the primary purpose of searching for the date that Judge Selman accepted the withdrawal of Courtney Dickerson's attorney without appointing him another attorney, essentially, manufacturing a false waiver by conduct allegation against Mr. Dickerson's Sixth Amendment right to an attorney. My work on the public access computer was abruptly halted because Mrs. Odom went out of her way to willfully and intentionally harass and annoy me and did so by interrogating, badgering and belittling me. Apparently, she was offended by another Facebook comment that I made to my friend, meant to convey his obligation to aggressively monitor his case and court dates. In criminal cases, the state of Alabama has no intent to prove actual receipt of notices and holds the defendant absolutely liable for failure to aggressively monitor his or her case or otherwise actively defend themselves from errors in receiving notice of court dates. Even if the post office loses the notice or a disgruntled spouse or roommate willfully destroys or hides the notice, the defendant has no defense. As long as the official records indicates that the notice was sent out, the defendant has absolutely no defense to a failure to appear charge. This is because they no longer enforce the bail jumping statute. During this confrontation, Mrs. Odom became aware that the sheriff's office was denying release on bond to everyone who is incarcerated in the Walker County Jail until the $35 bond fee is paid. Additionally, that I did not have a receipt for the money order that my mother and I used to pay the bond fee earlier that day on a second offense, nor was we given a copy of the bond transmittal form. And she also became aware of my fear that my mother would fall victim of a known pattern and practice of abusing the court's contempt powers. In this practice, judges issue arrest warrants for contempt of court without setting bail or with an unlawful, no-bond order, and then the clerk's office sets a court date at or about 30 or 60 days after arrest, where the defendant is tried, usually, for one count of criminal contempt, and 5 days is the maximum authorized term of imprisonment. See the attached case numbers in the description for examples of this judicial roguery case. and she admitted knowing that the contempt charges for failure to pay the fine within 2 days of execution of the bond is brought against the surety and not the bailee. She also brought up the subject of my marijuana advocacy and then told me that I was lucky that it was not up to her about prosecuting me. Shortly thereafter, I decided to leave just to get away from this critter. She added something about changing the law and I then reminded her that I was prosecuted for attempting to change the law. She then claimed I did it wrong. I see no error in openly bragging about successfully defeating the burning desire to kill a low-life administrative officer of the court, who would willfully abuse their judicial discretion. I see no error in citing this past desire and the reasons it occurred as evidence to support changing the laws, procedures and/or the pattern and practices of local government officials. Anyways, upset and stewing over Mrs. Odom's overt attack, I was almost in the town of Parrish before realizing that I had not yet picked up my sister from work. I stopped back by the courthouse and wrote down the date that I was originally looking to obtain, and did so without any interruptions. On March the 10th of 2015, I went to the clerk's office with the intent to find a remedy that protected my mother from the contempt charge and to attack the plausible deniability that Mrs. Odom throws around with such a blatant and offensive arrogance. Mrs. Odom admitted that the sheriff's office was acting as her agent when accepting these money orders, but claimed that she could not provide me a remedy that protected my mother from a contempt charge, and implied that she was powerless to stop the violation of the imprisonment for debt provision of our state constitution. It's on 'em, the magistrate kept repeating. I then left the office, promising to escalate the issue further. I then learned that the car that I drove to the courthouse would not start. While waiting on my friend to come and help me, I realized that canceling the money order and getting another one would be the best option, at this point in time. When I returned to the clerk's office, I asked for Mrs. Odom. When she came out to help me, I informed her that I had cancelled the other money order and had another money order and asked, "What are you going to do?" She then banned me from entering that office, ever again. I then said, "Do you understand the concept of failing to perform a duty?" Some purposefully placed law enforcement officer then said, "You're about to be forcibly removed." At all times during this event and that of the previous day, I was in full compliance with and wholly cognizant of Article 1 Declaration of Rights, Section 25, right to peaceably assemble and petition for redress of grievances, etc., of the Constitution of Alabama of 1901 and Section 13A10 disorderly conduct, though I'm sure they will claim my form was wrong. They always claim my form is wrong. I object to the notion that my form has ever been so flawed that it nullified or voided the substance. On April the 17th of 2015, I called the clerk's office to inquire about him receiving the bond fee that was paid on March the 8th. The specialist claimed she had not yet processed all of last month's bonds and she had to look through the bonds, and then she asked again what my question was about the bond. I had to tell her for the third time that I was wanting to know if they received the bond fee yet. She replied, "Of course we did. We have the bond." I then added that I just wanted to make sure it was not lost or willfully destroyed. On April 26 and 27 I sent out emails asking Mrs. Odom, 1. To lift the ban on me entering the Walker County Circuit Clerk's office, 2. What are the administrative procedures, if any, to appeal your act of banning me? On April the 30th of 2015, I went to the Cullman County Courthouse and looked up the two cases. I learned the court record reflects 1. A transaction between us and the clerk's office occurring on April the 7th of 2015. 2. Both the bond and bond transmittal forms have a warrant number and case numbers on them. 3. The numbers were added after the documents had been signed. 4. I was added as a witness to the Pye case. The act of refusing to accept the replacement money order violated Section 13A10-130, 3. Interfering with judicial proceedings, of the Code of Alabama. Also, the practice of denying release until the bond fee is paid, are violations Title 18 U.S.C. Section 241, Conspiracy Against Rights, and Section 242, Deprivation of Right under the color of law, in that the practice willfully exposes all bailable persons incarcerated in the Walker County Jail to excessive bail, equal protection, and denies people due process of law. On March 10 of 2016, I attempted to swear and attest to a criminal complaint for the arrest of Little Miss Odom. Presiding Circuit Judge Jerry K. Selman refused to read, accept, or hear my criminal complaint. The other two circuit judges were unavailable, which is something that I fully expected to happen, but I did it anyhow. Nah nanny boo boo. On March the 19th of 2016, a Facebook page for a local radio station, Walker County Area News, posted a story about a recent ceremony held by our local drug court, a diversion program, which was celebrating the graduation of 8 participants. The article mentioned Walker County District Judge Henry Allred, so, of course, I felt morally obligated to warn, once again, the general public of Allred's true nature and of the contents of his character by making a written statement, in the comment section, below the post containing the story. Shortly after, I published my short, but to the point remonstrance. Judge Selman's judicial assistant, Donna Perry, intentionally berated and publicly shamed me, and did so, in retaliation for me, daring to make such a comment. This beratement and public shaming was as follows. Very uncalled for. Wholeheartedly believing that my comment was just and true, I purposely escalated the argument by including even more local jurists in my public remonstrance of the 14th Judicial Circuit of the Unified Judicial System of Alabama. I've grown tired of begging my neighbors to strike a jury or, in the alternative, put a fracking bullet in my head. I then had a quick look at Little Miss Perry's Facebook profile page. I instantly became fighting mad over this braggart's unapologetic arrogance. So I made an accusatory statement, claiming she should know all about the willful abuses of judicial discretion in the 14th Judicial Circuit of the Unified Judicial System of Alabama. This accusational statement also called into question whether she was an employee of the Unified Judicial System of Alabama. Not only did this braggart have the audacity to reply again, but this braggart also made a statement that any reasonable person would believe to be a decree to prove to me that she was, indeed, a subject of the canon of judicial ethics. I gave Judge Selman the benefit of the doubt and asked his assistant to show him a recently published open letter from the United States Department of Justice, in the hopes that the boy would amend his practice of imprisoning people to coerce payment of debt. But I did so knowing full well that there would be retaliation inflicted upon me as a direct result of this confrontation. In Walker County, Alabama, there has been a culture of retaliation institutionalized throughout our justice system, while under Judge Selman's stewardship, as the presiding circuit judge for Alabama's 14th Judicial Circuit. As a result, good people have come to believe that it would be an error to fail to impose summary punishment upon folks instead of seeking punishment by and through the required due process of law. They even guilted one of my uncle's other nephews into doing it. He is not naturally inclined to act in such a manner. On March the 22th of 2016, Deborah Corrington charged the enforcement status of an old marijuana case of mine to made it appear that I was delinquent. Over a decade ago, in that damned old marijuana case, I had paid, in full, all that was asked of me, and I did so within 2 days of the Walker County Circuit Clerk's office finally getting around to telling me what I owed, of course. On March the 23rd of 2016, someone noted, in the official records of the same said old marijuana case, that a notice was mailed to the address listed on the long-settled and nearly forgotten marijuana case. On March the 26th of 2016, I was told that I had received mail at that old address. It turned out to be a dun, which informed me of a possible arrest, if I failed to pay an additional $277 within 10 days of receiving the dun. On March the 28th of 2016, believing that I was being baited into violating the oral ban on me entering the Walker County Circuit Clerk's office ever again, my mother went to the clerk's office, on my behalf, and purchased a copy of the official records for the aforementioned old marijuana case. It is currently a violation of Judge Selman's ill-conceived of orders, for me to send anyone to the clerk's office, on my behalf, without that person being escorted by a sheriff's deputy, at all times. I saw in the copies of the court records, a declaration of attorney's fee, a dun, filed by the attorney, who was forced upon me, during my initial appearance before Walker County District Judge Larry Lapivic. I was unable to find a judicial determination of my ability to repay, in the near future, the attorney's fees for services rendered in the district court and prior to indictment. I was unable to find an order that ordered me to repay the attorney's fees. I was unable to find an order or motion indicating that the court-appointed attorney had made an appearance or was mentioned, in any way, within the circuit court case, resulting from an indictment of the district court case, for which the attorney was appointed. I had a privately retained attorney employed after indictment. Also on March the 28th of 2016, with the help of an attorney, Richard Fikes, Susan Odom sued me in civil court, in her official capacity, for equitable relief. At the time, I had never committed Mr. Fikes' name to memory, but I knew that a senior partner for his law firm was currently being named, by a local paper of daily circulation, as the county commission's attorney. Sometime later, Mr. Fikes was named by a local paper of daily circulation as the county's attorney. Circuit Judge Drug Farris was initially assigned the case, but he recused himself within 17 minutes of the case being assigned to him. The case action summary lists 2 orders of recusal and reassignment. One at 3 hours 48 minutes and 40 seconds p.m. on March 28, 16. The other at 4:33:40 p.m. The second order of recusal and reassignment that was filed at 4 hours 33 minutes and 40 seconds p.m. assigned the case to Judge Jerry K. Selman. This order was issued by Judge Selman. The first order of recusal and reassignment that was filed at 3 hours 48 minutes and 40 seconds p.m. is not available for purchase. In fact, there appears to be 4 documents that were deleted from the electronic records of the civil case that Susan Odom filed against me, documents 2, 4, 5 and 6. Document 1 is a copy of Judge Farris' order of recusal. Because I assume they are automatically generated when judges e-file their orders, document 2 is most likely copies of all the e-notice transmittal papers for Judge Farris' order of recusal. Document 3 is a scanned copy of the summons and complaint. I am assuming that there is no e-notice was created because it was not e-filed. Document 7 is an e-notice transmittal for something that was at 3 hours 48 minutes and 39 seconds p.m. A fraction of a second before the first order of recusal and reassignment was e-filed. I am guessing that Judge Elliott recused himself, as he should have, and that Judge Selman assigned the case to Judge Elliott prior to assigning the case to himself. Document 8 is the second order of recusal and reassignment. Document 9 is the expected e-notice transmittal thing for the second order of recusal and reassignment. On March 29, 2016, I was served a copy of the emergency ex parte restraining order that the presiding circuit judge for the 14th Judicial Circuit for the state of Alabama, Jerry K. Selman, granted to Susan Odom in her official capacity. Mrs. Odom's affidavit makes it clear that the root cause of the rift between Mrs. Odom and myself is Judge Selman's derelictions of duties, pursuant to Section December 17, 24 of the Codes of Alabama. The $277 was paid, in full, a few days later. At or about an hour prior to the hearing of April 6, 2016, I cowered again and then, thinking long and hard about what and what not to say. I sent Susan Odom, in her official capacity, an email, by and through her privately retained attorney of record, and I asserted my Fifth Amendment right that protects me from being compelled to incriminate myself. Still to this day, this email has not appeared in the official records of the civil case that Susan Odom levied against me, in her official capacity, and all that implies. Additional relevant facts are as follows. On October 2, 2009, Vincent Roll was removed from his initial appearance before a judge or magistrate without having been appointed an attorney, bleeding out of his rectum and left begging for days for help before being found unresponsive on the floor of his jail cell. In 2011, Judge Selman was required to create and chair a voluntary indigent defense advisory board for Walker County, pursuant to Section 4 December 15 of the Code of Alabama. This board of so-called respectable Walker County folk created a local procedure for handling incarcerated people's assertion of the right to an attorney by changing the name of an affidavit of substantial hardship to an application for a public defender and forbade him from being given to the court during the initial appearance of judge or magistrate. On April 29, 2013, Walker County Circuit Clerk Susan Odom and Leela Yarn willfully refused to accept the hardship affidavit that I had prepared. On August 30, 2013, I filed a contempt complaint against them both. I served Mrs. Odom myself. My contempt petition was dismissed because my form was wrong, and the practice of diverting the affidavits from the official records continued. Proof that the Walker County Circuit Clerk's Office, the Walker County Jail, the Walker County Public Defender's Office was, at the time, forcibly hiding these hardship affidavits is in the fact that they were never stamped or scanned into the record until after they were adjudicated, if they do actually make it into the official records. A person cannot prove they have a clear right to an attorney, in a mandamus petition, if you cannot prove that they have asked the court to appoint one. Neither of my 4 hardship affidavits made it into the court records. I've always found it curious and a bit suspicious that on 2 occasions, the morning after I posted negative comments about the clerk's office, there was bomb threats allegedly called in. These 2 comments can be found in the list of links in the description below.